Hello and welcome back. Today's episode is a crucial one as we discuss the consequences of misrepresentation across the spectrum of Canadian immigration. Misrepresentation is when an individual provides false information or omits material facts on any immigration application to Canada. This isn't just limited to visitor visas. It extends to work permits, study permits, and applications for permanent residence. The consequences of such actions are severe and far-reaching. If discovered, the immediate result is typically the refusal of your current application, but the implications can extend much further than the present moment. One of the harshest outcomes is a ban from entering Canada for 5 years. This ban isn't just a delay, it's a red flag on your record that can disrupt your life and plans. It means no visiting, no studying, no working, and no chance at permanent residency in Canada for half a decade. For those who have already set foot on Canadian soil, a finding of misrepresentation can lead to being ordered to leave the country, even if you've obtained permanent residency or citizenship. The government can strip you of your status and initiate removal proceedings, which may include a ban from re-entering Canada for 5 years or more. But the repercussions of misrepresentation can echo beyond Canada's borders. In an era of international information sharing, this infraction can be shared with other countries, potentially affecting your ability to travel or immigrate elsewhere. A common type of misrepresentation we see is the omission of personal history, such as not disclosing previous visa refusals or overstaying a visa in another country. Applicants might think these details are in the past and won't come to light, but with today's data sharing capabilities, these omissions are often discovered and can lead to serious penalties, including deportation and bans from re-entering Canada. It's also critical to understand the concept of materiality in the context of misrepresentation. In immigration law, a misrepresentation is considered material if it could affect the outcome of the application or the decision-making process. This means that even what might seem like a small embellishment or an insignificant omission can be material if it has the potential to influence an immigration officer's judgment. For example, altering employment dates to cover gaps in one's work history, inflating income, or downplaying past legal issues are all forms of misrepresentation that can be deemed material. These aren't just white lies. They're viewed as deliberate attempts to deceive and can lead to the refusal of your application, loss of status, or even criminal charges. So, what should you do to avoid these dire consequences? Always be thorough and truthful in every detail you provide. If you're unsure about any part of your application, it's imperative to seek professional and reputable legal advice. Remember, the responsibility for accurate representation lies with you, the applicant. Even if you're using the services of an immigration consultant or lawyer, you must ensure that the information provided is complete and truthful. To summarize, misrepresentation in any form is a gamble with stakes too high to justify. Protect your future, your integrity, and your dreams by staying honest in your immigration journey. Thank you for tuning in. Please like, share, and subscribe for more insights.